One of our values here at Mohammed Mwigai LLP is mastery. What that means is we don't shy away from the difficult cases, nor should we shy away from commentary on such cases. The case we'll discuss today is one such difficult case. It is the Supreme Court's decision in petition number E35 of 2023, FAAF versus RFM and two others. It is a case concerning the right of children born out of wedlock to a Muslim father to inherit from his estate, contrary to Islamic law on that issue. The case has generated, as it should, robust commentary from different voices. Please join us for what we hope will be an edifying discussion between a litigator and an amateur philosopher on one hand, and a litigator and a practicing Muslim on the other hand. My name is Gabriel Mwangi, a partner here at Mohammed Mwigai, specializing in dispute resolution, and I'm joined by Nimo Adan, an associate also specializing in dispute resolution. Karibu sana Nimo.
Thank you, Gabriel, for the wonderful introduction.
And salam alaikum.
Alaikum salam.
Excellent. So Nimo, for the sake of our audience, perhaps we can start with the facts of the case. What was this case about?
The fact of this case began from the Qadi's court sometime in 2015. It was filed sometime in 2015. It related to the estate of a Muslim man who had died. His wife then, and let's, for the ease of reference, we'll call her the appellant before the Supreme Court, had approached the Qadi's court seeking to distribute his estate in accordance with Islamic law. She named herself and her 4 children as beneficiary. Around the same time, proceedings had been instituted before the High Court. Succession proceedings had been instituted before the High Court by the lady who is referred to as the first respondent before the Supreme Court. Her case before the High Court was that she was married to the deceased, that's a lawful wife, and that they had 3 children together. While the 3 children were born outside the wedlock, she still wanted her children to be considered as beneficiaries of the deceased estate. There was also another party before the High Court who appears as the third respondent before the Supreme Court. She also, her case was also similar to the first respondent. She said she was the wife of the deceased and that they had 1 child together, and that she also wanted the child to inherit from the deceased estate, although the child was conceived before they had concluded an Islamic marriage. Now, because of the existence of the case before the High Court, there was no determination of the dispute before the Qadi's court. The file was transferred to the High Court and High Court made a determination. So what the High Court found was that it did appreciate that the deceased person was a Muslim man and the applicable law was Islamic law. However, the court had proceeded to determine that even if the deceased was a Muslim man and Islamic law was the applicable law, these 3 children could not, the children who were born out of wedlock still had to inherit from the deceased estate. And this was subject to DNA test, of course, being done for the children that were born out of wedlock so as to determine paternity. Aggrieved by the High Court's decision, the appellant approached the Court of Appeal, seeking to overturn the High Court's finding. The Court of Appeal's decision largely turned on 2 articles: Article 27 on discrimination and equality, and Article 53 on the rights of a child. The Court of Appeal was of the view that children, whether born within the confines of a marriage or outside the confines of marriage, ought to be allowed to exercise their right to inherit, and that there was no justification or rationale for why the children born out of wedlock should not be allowed to inherit from the deceased estate. With this reasoning, the Court of Appeal then upheld the High Court's finding that all these children, whether born within wedlock or outside wedlock, should inherit from the deceased estate. And there was also High Court finding that a DNA test ought to be done on the children who are born out of wedlock so as to establish paternity. The Court of Appeal set aside that order, given that this issue of DNA was never an issue substantively considered before the High Court. And of course, the appellant before Supreme Court was aggrieved by that finding. And given that it was a weighty matter, a constitutional question, particularly on the applicability of Islamic law, the matter then proceeded to the Supreme Court. And I know the Supreme Court had framed several issues for determination.
Yes. And Nimo, thank you for that elaborate factual and litigation history until we got to the Supreme Court. And the Supreme Court then framed issues for determination. It framed 4 issues. But before we even get to the framing of those 4 issues, I think it's a good starting point to look at the court's frame of mind when you look at the very first sentence of the judgment, where the court was saying that the appeal before it presents a question which sits at the intersection of religious pluralism and the right to equality. I think there's a third element which was missing there in terms of the hierarchy of laws, especially when you're dealing with religious law. But we'll get to that in the course of this discussion. So the Supreme Court then frames 4 issues for determination. The first one is whether it has the jurisdiction to entertain the appeal. This is not an issue that was contested by the respondents, but the Supreme Court still found that it needed to address itself on the question of jurisdiction. My guess is that because of the history of the litigation, I mean, it's supposed to be a succession matter, which would normally not entail constitutional questions, but because this one specifically involved constitutional questions and the court had been moved as of right, I think the court needed to clear that hurdle first, which is fine. Then the second issue the Supreme Court framed is whether the Court of Appeal erred in limiting the application of Article 24(4) of the Constitution, and in so doing, whether the Court of Appeal misconstrued the relationship between Article 24(4) and Article 27 of the Constitution, which you've already mentioned. Then the third issue the Court of Appeal then framed, the Supreme Court framed for its determination, is whether the Court of Appeal erred in failing to uphold the mandatory provisions of Section 2(3) of the Law of Succession Act concerning the application of Islamic law in those kinds of matters, and finally what orders were to issue. So those are the 4 main issues framed by the Supreme Court. Of course, with the overarching issue which I mentioned at the beginning. In brief, because I know we'll go into a bit more detail about the Supreme Court's findings, but what did the Supreme Court find, just in brief?
Okay. The Supreme Court's decision turned on the interpretation and application of Article 24(4). And for the benefit of the audience, Article 24(4) relates to the applicability of the principle of equality to Muslims. Now, that particular article, the way it's worded, it says that the principles of equality would be qualified to the extent strictly necessary for the application of Islamic law to persons who profess Islamic faith and for personal matters before the Qadi's court. Now, the court largely relied on the phrasing of the article that says to the extent strictly necessary in its determination. The court was of the view that while Article 24(4) allows for a limited derogation from the principles of equality, and particularly to Muslims, so as to allow for them to apply the personal Islamic law, it was not an absolute immunity. It was qualified. And so the court was of the view that any derogation or any qualification still had to meet the proportionality test under Article 24(1), meaning that any exemption would have to be reasonable, justifiable, and proportionate in a democratic society. With such a reasoning, the court then, while it appreciated that this was an Islamic principle, it found that it clashed with Article 27 and Article 53 on the rights of a child. And given that conflicting positions, the court could not then uphold the Islamic principle over this constitutional value of equality, principle of equality. So the court's decision largely turned on that interpretation of Article 24(4), and ultimately it affirmed the Court of Appeal's decision that all these children are allowed to inherit from the deceased estate. Yeah.
To my mind, when I try to read the commentary and listen to the voices that have come out about this decision, there seems to me to be 2 divergent schools of thought. And I think the benefit of having a conversation like this is we can tease out what these respective positions are, because it's better to have a discussion rather than talking at each other. So I think the two divergent schools of thought, which in my view, seem to be speaking at cross purposes. The first one says, look, matters relating to the personal status, marriage, divorce, and inheritance of persons who profess the Islamic faith are exempt from constitutional scrutiny. Then the second school of thought says the Constitution is total and supreme. Hence, matters relating to personal status, marriage, divorce, and inheritance of people who profess the Islamic religion are subject to constitutional scrutiny. So I think those are the two divergent schools of thought. And I think I would want us to discuss that a bit. Maybe you could take the first argument, then I take the second argument. So starting with the exemption argument, if you don't mind, just giving us some history about Sharia law, its origin and its meaning to practicing Muslims.
To appreciate the exemption argument, we have to look at the origin of Islamic law. Now, Islamic law is what we consider as Muslims to be divine law. It is literally the word of God, which was then revealed to our Prophet Muhammad, peace be upon him. They are generally four primary sources of Islamic law, the first being the one that's famously known, which is the Quran. The Quran is the most authoritative and complete code. It is the literal word of Allah, and it provides for the general principles in Islam. So things like inheritance, justice, morality, trade, it provides the general rules. And then the second primary source of Islamic law we have is what we call the Sunnah. Now, the Sunnah are the actions and the sayings of Prophet Muhammad, peace be upon him. They sort of explain some of the general teachings or the general principles in the Quran. They explain them. And then third, we have what we call ijma', which is in English terms consensus. So it's an agreement amongst scholars as to what the general principle is. So this is applicable where there is no clear guidance from the Quran and the Sunnah. So where there's guidance, but it's not very clear, as a group of Islamic scholars would agree that this is the best way to go about something. So hence the consensus. And the last one is what we call qiyas, is analogical reasoning. So for this, it's a method of reasoning in Islamic jurisprudence where the scholars then use or rather derive rulings or come up with rulings of a new issue based on established rulings and principles. So this is applicable where there is, can I say, a lacuna, in the Sunnah, in the Quran, or in the Ijma' consensus. So we applied, already existing rulings to newer situations, right? So those are generally the four sources of Islamic law.
So if I'm understanding you correctly, then if we're talking about Islamic law, one, its nature is that it's divine, according to your faith, which makes it a bit interesting, because maybe that's something that should have been emphasized a bit more in terms of what this law means to Muslims. In fact, I think I read somewhere that the definition of Islam is subjection to the will of God.
Absolutely. It is. It's a way of life. Through these four primary sources, it's a complete code of life. It's a complete, it's a comprehensive code of how Muslims should live. So everything that we do, we derive it from there. The do's and the don'ts in Islam are all within these four sources. Now, because of Islam, it being a complete code of way of life, we find that Muslim communities have always wanted to be able to practice that wherever they live. And this context is important, particularly if we talk about the role of, or the place of Islamic personal law in Kenya. And let's take us back to pre-independence Kenya. So, the coastal strip belonged to the Sultan of Zanzibar, which had given the British the powers to administer that coastal strip. And so at the time when Kenya was gaining independence, there were conversations of what do we do about this particular strip. And the Sultanate was happy to, of course, cede it to Kenya for it to form part of the Kenyan territory under certain conditions, which led to the 1963 Coastal Strip Agreement between Kenya, the United Kingdom government, and the Sultan of Zanzibar. Now, this tripartite agreement between the three parties had ceded the coastal strip to Kenya on certain conditions, and among them are two very key conditions. One, that the persons who live on that coastal strip would be allowed to profess the Islamic faith and practice Islamic faith. And two, that the chief Qadis courts, which by then had existed on that strip, would be allowed to determine issues of Islamic personal law. Right, and so that the 1963 agreement, in as much as it's a historical pact, it was sort of a social contract between the Kenyan governments and the Sultan and the British powers, that persons living in Kenya would be at liberty to profess their faith and practice it, at least with regards to the matters that touch on their personal status, things like inheritance, divorce. Yeah, so there's that guarantee. So for the longest, Kenyans have always been under the impression that this is a right that's guaranteed to us. Yeah. Now, I know sometime in 1964, once Kenya gained independence, there were discussions of, Kenya didn't want to at least be bound by some of these colonial agreements that they had. And so they wanted to forego some of them. So 1964, the late Mzee Jomo Kenyatta had presented a list of the agreements that Kenya wanted to, not to be bound by post-independence. But the 1963 agreement was not part of those agreements. In fact, what Kenya did is immediately it got independence, it then incorporated the Qadis Court, which was one of the conditions in that agreement. It incorporated Qadis Court into the 1963 Constitution. So Chapter 5 of the 1963 Constitution provided for Qadis Court under the Judiciary chapter. And so, if anything, the 1963 Constitution was evidence of, Kenya upholding that pact, that agreement, or rather implementing it. Yes.
But it's an interesting fact that when you're talking about these arrangements that were in the coastal strip, and the decision we were talking about actually emanated in Mombasa, and the deceased, I think, died in Tanzania. So it's a nice piece of history that the locus of where all this was happening and being negotiated many years down the line turns up in a dispute in court coming out from Mombasa. So post-independence, we've had, you've mentioned that the tripartite agreement was not amongst the agreements that Kenya didn't want to be bound by. And they now take us to 2010.
So with the making of the 2010 Constitution, the Muslims were actively participated in the making of it. Muslim organization were represented in the Constitution of Kenya Review Commission. There were committee members. We had Muslim members, professional organizations. We had Muslims who sat as part of the NGO. So we had active participation in the making of the 2010 Constitution. In fact, one of the more famous Muslim entities, the Supreme Council of Kenyan Muslim, SUPKEM, was at the forefront of fighting for Muslim rights in the making of the 2010 Constitution. We were part of the Ufungamano initiative as well. So there was a whole back and forth with regards to having the place of Qadis Court in the 2010 Constitution. A lot of some of the non-Muslim organizations had fought it, saying that including it in the Constitution would be Islamization of the Constitution. But really, that wasn't the case. The place of Qadis courts in Kenya had been cemented from the 1963 Constitution. So if we're being honest and we're being clear, Muslims had negotiated and fought for its place in the 2010 Constitution. And that's why we have Article 170 on the Qadis Court available. This also brings us to the place of Article 24.4. That's the way that article reads isn't by default, right? It's because as I said, Islamic law is based on divine law. And so what we would call equality under secular law is likely to conflict with what we would consider equality under Islamic law. And it's in that recognition that we have Article 24.4, so that these principles of equality are then qualified when it comes to Islamic law. Yeah.
So, and I can sympathize with that argument if the argument is that Muslims understood that in the process of coming up with this constitution, you negotiated to have a space where your law would apply, appreciating that that law could conflict with other provisions of the constitution, and Article 24.4 seems to be specific about the provisions on equality. Why I sympathize with that argument is that if we had all these Muslim organizations participating, then most likely that's what informed the drafting of that particular article, recognizing that we know our law, and our law most likely will conflict with especially the equality provisions, so reserve this space for us. And maybe when I was just thinking of this issue, coming from my own faith background, being Catholic, where we have good theological reasons for only having male priests, as an example. But you might wonder then, would we entertain a challenge, a constitutional challenge, based on equality and non-discrimination because of that practice? How would the court deal with that? There are some faith groups who don't believe in blood transfusions. So if a child needs a transfusion and they belong to that, and their parents belong to that faith, then how do such issues, how are they resolved? Which I think is part of this discussion. But let me ask Nimo, what is the rationale in Islamic law for excluding children born out of wedlock from inheritance?
To answer your question, Gabriel, on why, on what the rationale is, inheritance in Islamic law is provided for in the Quran, which, like I said, is divine law and is the most authoritative text on this particular issue. In our inheritance in Islam is not just about dividing wealth. It's not about just distribution. It's bigger than that. It's about protecting the integrity of, lineage and family units, and preserves family units. Now, in Islam, inheritance is through lineage, and lineage in Islam is always tied to the father, to the biological father. Now, lineage is recognized within the concept of marriage. Where there is no marriage, then a child born out of that relation cannot be considered a child of the father. It is considered a child of the mother. And all the rights of that child, including the right of inheritance, all trace back to the mother only, right? And the reason for that, Gabriel, could be there are no contradictions in Islam. Primarily, Islam forbids both premarital and extramarital relations. Now, having consider that a sin and does not permit for that, we can then not say an outcome of that would be considered or could be treated as any other child, right? So because there are no contradictions, given that we've prohibited premarital relations, we can't reward the outcome of that premarital relation. So when it comes to children born out of wedlock, Islam strictly forbids them from inheriting. But this is not because it intends to punish the child. No. In fact, Islam is very strict in when it comes to children. You are not allowed to mock those children born out of wedlock simply because of their circumstances. It is, in fact, a sin to do that. But what Islam has done is that there's a more compassionate alternative, which is you can provide for that child, but through what we call through a bequest, or a wasiya, as we call it. Now, as a Muslim person, you can only give away 2/3 of your estate to the heirs that are recognized in the Quran. You have 1/3 of your estate to will it to people who are not considered your heirs. Now, among the people who are not considered your heirs are children born out of wedlock. So you can provide for that child, but only within the confines of that 1/3. But you have to be able to will it away while you're still alive, so that in the event you have passed away and you've not provided for this child out of your out of 1/3 of your estate, then they cannot benefit from the 2/3, because the Quran is already clear on who are entitled to the 2/3 of your estate. The fixed distribution schedule provides for the different degrees of your relations that are entitled to 2/3 of that estate. And a child born out of wedlock does not feature in that 2/3. Yeah.
Sometimes for someone who's outside your faith, the exemption argument can sound so outlandish because, I mean, if you're not party to the thinking that informs some of these rules, it can look very strange. Although we are aware that there have been at least 2 judges. There's one decision of a judge in Mombasa who seemed to uphold the very same argument. This is the case of CKC and another versus ANC by Justice Mugure Thande in Mombasa as well. Although I do know that was overturned on appeal. But the point is, one could still have a reasonable basis to make the argument. It's not as outlandish as many people might want to characterize it. And I think in that particular matter, the judge said, look, this is what Article 24.4 means. The court's hands are tied. As long as the matter falls within the category of Article 24.4, then we have to defer to Islamic personal law. So I can sympathize with the argument. But there's this other side of the argument, now this the subjection argument. And to start with, the Supreme Court was interpreting the qualification under Article 24.4, the particular qualification about to the extent strictly necessary. And to the Supreme Court's credit, it borrowed from a lot of sources. It looked at scholarly sources, scholarly articles by, for instance, Professor Christina Murray. It looked at international conventions, ICCPR as an example, and the interpretations about similar kind of wording. It looked at a Botswanan decision, which was not really about Islamic law, but about customary law. So the Supreme Court seems to have borrowed quite a bit from other jurisdictions as well in trying to interpret Article 24.4. And to me, it seems to be hinting at adopting the integration approach to the management of religious pluralism. Because there are 3 general approaches. There's the accommodation approach, where we say, for whatever practices that a particular faith has in a society, a pluralistic society, will accommodate you by not interfering at all in your affairs. Then on the other end of the spectrum is the assimilation approach, where a society takes the position that all practices, whether religious, cultural, customary, whatever it is, needs to be assimilated into a larger framework, a larger normative framework. Then you have somewhere in the middle, the integration approach, where the society says, yes, we recognize that we are ethnically or religiously diverse, and we champion that. But if a particular practice conflicts with these broader norms that we've agreed on, then those practices need to be integrated into the broader normative framework. So my question is, what would be objectionable about this approach that the Supreme Court took?
No, I think why the Supreme Court's approach is objectionable, and particularly to Muslims, is because we really do believe that Islamic principles or Islamic values are, derived from Islamic law, which is divine law. And given that it is divine law, we have no say in framing it. We don't sit as a group and decide this is what is going to be Islamic law. It is what God has ordained, right? And we have a duty as Muslims to obey that particular law. Now, when it comes to appreciating the place of Islamic law and within the Kenyan framework, it's because the Constitution of Kenya and the constitutional values have been framed from a somewhat secular frame. It's a semi-secular framework of sorts, but Islamic law is divine law, and that those values are not always going to see eye to eye. They're going to be diametrically opposite on certain issues, and if we are going to then qualify the application or the right of Muslims to practice Islamic law, then what that means that every time there's an issue with Islamic law, you open that Islamic law for challenge on a constitutional ground, like in this particular instance, this particular case. So if Islamic values can be challenged on constitutional grounds, and the Constitution, being the supreme text, takes, wins over the Islamic principle, then as Muslims, we feel like we won't be able to practice our law or our faith holistically as we have been, as we thought we were able to do for the longest. So with that decision, what we think is that the court is somewhat in a way clawing back these rights that we've been given. We have Article 32 that says freedom of religion. And freedom of religion means as a Muslim, I have to be able to live my way of life in accordance with that, with Islamic law. And so if in any situation my way of life clashes with the Constitution, then and the Constitution takes the day, as a Muslim, I am at the end of the day not practicing. I do not have that right of freedom to practice my religion. And perhaps just to address the third issue that the Supreme Court had framed is on whether the Court of Appeal had failed to give effect to the mandatory provisions of Section 2(3) of the Law of Succession Act. The court had determined that it did appreciate that the deceased was a Muslim man and that the state ought to be determined in accordance with Islamic law. But then it went ahead to say that any religious law or any cultural law, or rather any law in Kenya, has to be interpreted and applied through the lens of the Constitution. And for this particular reason, given that Islamic law conflicted with the constitutional values and constitutional principles, then the Supreme Court could not uphold such a law because it failed because it was in conflict with the constitutional principles. Yeah, and so for this reason, in as much as that law, Section 2(3) of the Law of Succession ought to have applied, it could not apply in this particular instance because the court could not uphold a law that says children born out of wedlock are not allowed to inherit from their father's estate. Right.
In fact, practically, I wonder if then that's the case, then which law was the High Court judge supposed to apply? Would it then just be the Law of Succession Act?
You see, that's the dilemma we're having as Muslims, because there's a reason we're allowed to, to have Islamic personal law applied to us. So if you recognize that this is a Muslim person and you recognize that his estate, that there's certain laws that should be used to determine his estate, why then, deny to do that or fail to do that?
Okay, in that you make some interesting points which I need to talk about. One, on the question of supremacy. What I found interesting is that when the Constitution uses the word supreme or supremacy, there are only 3 instances where it does that. One, in referring to itself as supreme. 2, when it's referring to a particular forum, the Supreme Court. But at the very beginning of the Constitution, it talks about we, the people of Kenya, acknowledging the supremacy of Almighty God of all creation. So the idea that the Constitution is purely secular might not be the case because it's replete with also references to God. I think that maybe it's the interpretation of the Constitution which might be informed by a secular mindset on the part of the decision makers who are entertaining these kinds of disputes. But that's my view. In fact, when I was just thinking about this discussion, something came to my mind about the nature of our laws in Kenya, whether we can truly say they are secular. Because there's a historian who makes this argument called Tom Holland, that before the advent of Christianity, if you're to look at the laws that governed those societies before Christianity came in, there's a radical difference. Because Christianity seems to have introduced, for instance, protections against vulnerable people, as an example, which were not there before, where it was might makes right. So sometimes for us who've inherited through colonization these laws, we might presuppose that they are neutral when they are not, especially to people who are outside these kinds of legal systems. For instance, Muslims as a minority in Kenya, which is an interesting point. But anyway, the other very compelling argument on the subjection side is to say, and this also informed the court's decision, the sins of the parents should not be visited on the children. And it's a very compelling moral point because the children have nothing to do with the relationship between the parents, and especially in this case where the deceased conduct seems to have suggested that he recognized these children as his own. Now, you did mention that in Islam you're allowed through a will to bequeath part of your estate to this category of people. So if that's the case, if Islam seems to have allowed a man or a woman to do a will and bequeath to this category of people, then it's not too far of a stretch to recognize the rights of these children to inherit, even where a will is not there. What would be your thinking about that?
Gabriel, I have to respectfully disagree with the Supreme Court in as much as it is, yes, in a way, a morally compelling argument that is it really a stretch for these children to be allowed to inherit, given that there's provision for them through a will. Now, where there is no, even turning to our own law of succession, there's how you treat the estate of a deceased person where there's a will and where there's no will is different. We treat testate and intestate successions, differently. And so the same thing with Islam, where you have died intestate, then your estate has to be determined in accordance with Chapter 4, which is now the fixed distribution schedule. And in that schedule, the rightful heirs of the deceased estate have been identified, right? And so the Quran is clear as to who has a right. Now, children born out of wedlock don't have a right. That is very categorical. And so even with the compelling moral argument, we can't interfere with what God has said. He has said that these are the heirs, these are the people who are entitled to benefit from this estate. So children born out of wedlock we can't fix them in there. We can't say there's a moral argument for us to include them in there. It would go contrary to what, as Muslims, we believe to be the word of God, and we can't do that. Yeah. So there's a moral bit of it, but looking at it from the Islamic lens, it is not something that we can alter. Yeah, there's no room for modification.
Maybe to answer the argument, is there, or what's the fate of these children? Will they be left completely destitute, or does Islam have, apart from this, the will option, does it have any other ways to cater for these kinds of children?
So there are two avenues for that. One is the child has a right to inherit from his mother's side. So his mother and her side of the family, that child has a right to inherit. The other second alternative is in an ideal Islamic society or within an Islamic state, the child could be catered for through what we call Baitul Mal, which is, it's a goodwill of sort within the Islamic community. So a child, they will not be left destitute. It will be the responsibility of the state to cater for these children, in terms of shelter, food. So that would be an avenue they can benefit from, where this, it's an Islamic state. But unfortunately, I know that in Kenya we're not. But still, even that's not a reason enough for us to interfere with God's rationale for why children born out of wedlock cannot benefit from the estate of the deceased.
Would you know, even though Kenya is not an Islamic state, would you know if there are any informal mechanisms, whether it's through civil society or NGOs, specifically Muslim ones, dealing with these kinds of children?
I know there are many Islamic charitable organizations within Kenya. So that's one of the avenues. We have Waqf also, which is a form of charity within the Islamic community. So those are avenues where these children perhaps can seek help. But it's not that children will be left out to be destitute. We have the equivalent of children's home and orphanages run by Muslims. And so in terms of education, shelter, food, they all they can get something.
Okay.
Yeah.
I think the third element of the subjection argument has to do with the fact that Article 24.4 seems, even if we were to grant that it means what you say it means in terms of the exemption argument, even if we were to grant that, the dispute could still be decided by looking at a different provision of the Constitution, and that's Article 53 on the rights of a child. So while we might say, okay, the provisions of the Bill of Rights on equality shall be qualified to the extent strictly necessary for the application of Islamic law for these particular matters, fine. But what if you look at Article 53 on the best interests of a child, which include the right to their parents' care and protection, notwithstanding the marital status of the parents? How would you be able to confront that argument?
Now, see, when we say the application of Islamic law to marriage, inheritance, and all of that, I think it covers the broader topic, which is also the rights of children. Yes, the Constitution recognizes that, but also in Islam, we do have rights of children. In fact, children are one of the most favored members of society within Islam in itself. And so, while we recognize that's what Article 53 says, it cannot overpower what the provisions of Islam says in respect to children born out of wedlock. And what I said earlier, that the constitutional principles would always be diametrically opposite, or would in most instances be diametrically opposite to Islamic values. So while the Constitution recognizes, the rights of children to be provided for by their parents, both parents, in Islam, that right is available for children, but children born within the confines of marriage. So children born within outside the confines of marriage do not enjoy that same right, particularly on the issue of inheritance. Well, yes, your father can recognize you even if you're born out of the wedlock, and caters for you, provides for you. In the event your father dies and does not leave a will or does not provide for you, then you'll not be allowed to inherit. That still stands. Yeah, so even appreciating the rights of children and Article 53, still that cannot supersede that particular argument, because that's a divine law that's already been established in Islam. Yeah, so again, diametrically opposite, and that's...
Nimo, as I was thinking about this decision, and not just of the Supreme Court, but of the Court of Appeal and of the High Court, and not just in this matter, but in the other matters that have been referenced, it seemed to me that maybe the courts are interpreting Article 24.4 in reverse, because Article 24.4 seems to be saying that the provisions of the Constitution or of the Bill of Rights on equality shall be qualified to the extent strictly necessary for the application of Muslim law for this category of matters. Article 24.4 is not saying that the principles of Islamic law will be qualified to the extent strictly necessary for the application of the provisions of the Constitution on equality. So to my mind, I was wondering, that seems to make a difference in terms of the analysis that the courts have been doing. Do you see that as well?
Yes, I agree. And I like that you brought that out, because what the court actually did was the latter option. What it did is try to qualify Islamic law to fit into the Constitution, as opposed to having to qualify the provisions of the Bill of Rights when it comes to application of Islamic law. Yeah, because if it had actually interpreted the article as drafted, then what the court would have would perhaps have done is appreciate what the Bill of Rights say, appreciate what the Islamic perspective of this dispute was, and then now qualify the provisions of the Bill of Rights to fit into what the Islamic legal framework provides for. I think that would have been the right way to go about it. But I get it that they actually did the reverse. It was qualify the application of Islamic law to fit into the Bill of Rights. Yeah.
The jury will be out there about whether that makes a difference. But in terms now of the way forward, following up from this decision, because I noticed that the appellant represented herself, and we didn't see any involvement of, for instance, SUPKEM in the litigation. Do you think maybe that would have made a difference?
Absolutely, it would have made a great deal of difference, because I think you earlier mentioned that the court had borrowed, jurisprudence from other jurisdictions. It had borrowed texts from various other sources. What the court didn't have before it was Islamic voice. It did not have what the Islamic rationale or the Islamic justification for this particular issue. And in Islam, inheritance is such a sensitive issue. So that ought to have been before court. And unfortunately, that didn't happen in this particular matter. I wish Supreme had been, a party to this particular proceeding, but that didn't happen. I think moving forward, and perhaps this can be something that maybe the Supreme Court, in its attempts to be proactive, can do, is invite members of the communities to be affected by the decision you're making. And, particularly when it comes to matters of great public importance, it would be good for the court to hear, for the people to be affected, for the particular group of people who are going to be affected by that particular decision, so that when they make the decision or they're making the ruling, it's a contextualized one, it's a wholesome ruling, and it also then fully appreciates what the impact of the decision would be. You see, and the reason I say the impact of the decision is because in this particular instance, we are opening up Islamic principles to be challenged on grounds of constitutional principle and values. So that can be perhaps one of the way forward, is that the Supreme Court can invite parties. And I think other jurisdictions such as the South African Constitutional Court and in the India Supreme Court, they have this proactive approach where they invite, the marginalized group or the parties to be affected by this decision to come and make representations before it's, it's not enough to hear from the immediate parties, because the immediate parties before courts have an interest, and perhaps a selfish one at that. But if you invite the people to be affected by these decisions, then you would appreciate the broader implications of your decision.
That makes sense. Another thing which I found interesting about this case in terms of the way forward, initially, as you mentioned, there were proceedings, one before the Qadi's court, the other in the High Court at the first instance, and then the proceedings before the Qadi's court were merged with the High Court, and the High Court is the one that was now deciding this dispute. Yet we have Qadi's courts. I don't know what informed the concession on jurisdiction to have the High Court decide a matter which everyone agreed Islamic law applies. Maybe the only dispute was the extent to which it applies. And even with the outcome in the Court of Appeal and the Supreme Court, the dispute is still being referred back to the High Court to decide. So saying on the one hand, yes, we acknowledge that Section 2.3 of the Law of Succession Act applies to this dispute, but we have modified Islamic law because on this particular issue, it's unconstitutional, so the children born out of wedlock are entitled to it. But on the other hand, also the forum before which it's being taken before is not the Qadi's court. Is there a case, and I've heard it being said before, is there a case for insulating the Qadi's courts, including an appellate process, and that makes sense? Do Islamic principles change on appeal?
I don't think they'll change on appeal, but I think when we were fighting for the place of Qadi's court in the Constitution, we ought to have fought for it to be perhaps a superior court as opposed to a subordinate court. But even if you do have an appellate process, the principles still remain the same, right? The principles don't change. All the Qadi does is determine the disputes before him in accordance with the Islamic principles. So if you agreed by that particular decision, even if you appeal, if there's an appeal mechanism and you appeal that particular decision, the outcome is likely to be the same. There is no room for the Qadi to say, I know this is what Islamic law provides, but in this particular circumstances, it would be best if we, modified the law to say this or disregarded the law. That can happen. Like I said, Islamic law is immutable, and so the decision of Qadi's court at whatever level will still remain the decision. Yes, of course, there's room for making error or perhaps misapplying a law here and there, but the general principle to me would remain. And so in this particular case, I think maybe, the reason as to why the dispute found itself before the High Court, and I think the High Court should have recognized that even the petitioner before the High Court was clear that she was a Muslim, right? And it was in regards to the estate of a deceased Muslim man. At that point, the matter ought to have been referred back to the Qadi's court. I think the error was in hearing that particular matter, because the thing about the Qadi's court is you have to submit to its jurisdiction. So if you do not submit to its jurisdiction, then it becomes a challenge for the Qadi to hear that particular matter. Parties have to submit to it. Yeah.
Maybe finally, might there be a case for a hybrid system of courts where you have a non-Muslim judge, but with assessors who are Muslim scholars or Qadis? Because I think I saw in one of the decisions as we were preparing for this matter, I think by the late Justice Etiang, where he seemed to be referencing input from an assessor or two. Would that balance the concerns on both ends?
I think that system already exists. If you're appealing a decision from the Qadi's court and you get to the High Court, we do have assessors who sit with the judges, and I think there are two assessors who sit with the judges. Although the decision of the assessors are not binding on the court, all they do is just issue their opinion, and the court decides whether they want to be bound by it. Perhaps if we had a framework where we say this assessors, because the assessors are Qadis and they appreciate the Islamic perspective, if what the assessors' opinion, and assuming it's by majority and both of them have the same position, then the judge should be bound by it. Perhaps if there's such a framework, but for now, the assessor's role at the High Court is just merely to give an opinion. Yeah, the judge is not bound by it, so perhaps maybe look for an avenue to have them bound by it. Yeah.
Excellent. This has been a truly engaging discussion for me. I have learned a lot, and there's so much that we can talk about, but we'll end there for now. Thank you, Nimo, so much for your time and for sharing your views with us.
Yeah, thank you too. This has been truly a very interesting discussion. Not the easiest of topic, but quite interesting to have. Well, that brings us to the end of this episode. Thank you for tuning in. You will find this episode available on our YouTube page and on Spotify. We would love to hear your feedback on what you think about this episode.